So welcome to everyone who's joined us. We are happy to have Dawn Q with us here today to talk about estate planning. If you have any questions, post them in the chat and we'll get to them at the end of the program. So Dawn is a semi-retired certified financial planning professional and has been in the financial industry for the last 28 years. In the past 5 years, he has devoted more time to doing pro bono financial coaching for the community because he firmly believes in financial knowledge through financial education. So Dawn, welcome. We're so glad to have you. I'm going to turn it over to you and I'll come back at the end for questions.
All right, thanks, Jennifer. Good afternoon, everyone. This is Dawn Q, the Certified Financial Planner. I'm coming to you from Dallas, Texas. And can everybody hear me okay? First of all, I'd like to thank Miss Jennifer for putting this thing together. And just a little bit about myself. I live in this North Texas area for the last 49 years. Like she mentioned, I've been in the financial planning, advising, coaching for 28 years. And I'm pretty much right now is on the downside of my career. And so I devote much of my time to help people with financial knowledge through classes or seminar, webinar, one-on-one, just to get them to become more confident with planning for their financial futures. And you know, I've been involved with the Financial Planners Association, and I'm the volunteer advisor for the Catholic Charity of Dallas. And I also volunteer for an organization helping widows and widowers through a company called Wings for Widows. All of these are pro bono services to help the communities. So I'm very excited, very honored to be here this afternoon to kind of walk us through the basic concept of estate planning. And so with all of that being said, we can go ahead and dive in with the topic that we want to talk about today. So first of all, let's see if I can. So what is estate planning? We're gonna kind of get a little bit understanding about what estate planning is. And why do we need such a plan? And in order to understand the what's and why of it, we're going to dig a little bit into the basic of the wills and the basic of trust, what it is and what it can it do. And the plan would not be complete without some of those important legal documents associated with it. And all of the information that we learn would not do us any good most of the time if we don't have a plan to make it happen. So how to start a conversation with all of the loved ones and where to get help to make it happen. So let's get started with the question: what is estate planning? Well, you know, if you don't have a will or you don't have an estate plan, you are in a very big crowd, because more than 50% of Americans don't have a will. Even the larger number of Americans don't have an estate plan. And I think the most common reason for that is the fact that people believe that estate planning is only for the old people, or estate planning is only for the rich people, or the old and rich people. But that belief cannot be too much further from the truth, because every one of us should have an estate plan. Now, when people think about the estate plan, sometimes it's just too scary to really kind of even think about it, let alone taking steps to make it happen. But there's one painful fact that we need to know, we need to realize that every one of us has an estate plan. And one that you may or may not like it when you see it, or you don't even see it when it's happened. Because if somebody died without a will, then the state that you live in, your resident state, will have the state statutes and laws that govern your estate in that state. Will take over and they will make a decision for you. For example, if you have minor children, then a probate court judge might have to appoint a guardian for your minor children. Or even, nowadays, a lot of people own dogs and pets and different type of pets, and the courts have to appoint somebody to take care of the pets for you. And the person that the court appointed may not be the one that is number one familiar with your family or your children or your pet. So that's the very, very good and important reason for us to begin to think about planning for our estate. Now, as you will see the estate planning process that really involve several aspects of our life. And needless to say, let's start with the legal aspect, and then the financial aspect, and the human aspect of our life, as we see that when we go along. And so this can be as complex a process as you can make it. So for the purpose of this presentation this afternoon, I would like for us to focus on some of the basic concept. We take a look at at the 30-foot 30,000 feet bird's eye views of estate planning, and then one very high level concept, so that from there we can work on in a top-down approach, and we will going forward. So first of all, before we want to do an estate planning, to create an estate plan, what is an estate? When we hear the word estate, the first time or the second time, it sounds like some kind of castle in England, or some in Spain, or some place that belonged to a royal family. But for legal purposes, if you own a property, if you own anything, the moment you own that something or that anything, it's already created a estate for you. Simply put, in anything you own, create your estate. And so the estate planning is basically the instruction, the thought process, the wishes, that how do you want to transfer the estate to the people that you love, the people that you like, once you pass away. That's basically it's all about the estate plan. Because you can leave behind some real property, or the time that we live in the digital world, you might have some intelligent property, or some personal property, the rings and the jewelry that you own. You might want to give some to some of the son or daughter, or somebody that you love. So all of those assets comprise of your estate, and the estate planning process is to give the instruction to distribute those assets after you die. Now, the question of how to get those assets to, and when to do it. So the estate plan is the one that authorize the authority to, some people that can make the legal or the financial or even toward the end, the medical decision for you, in case that you're no longer around, or you're not capable of doing it. It's one thing before we moving on into the nuts and bolts of this process. One thing that irony about putting together an estate plan is that the one that putting that plan together probably get the least benefit from it. The plan that you put together is hopefully the one that benefit your loved ones the most. The family member, the extended family member, and who else that you put in the loops are the one that be benefit most from it. The one big benefit if you put together your own estate plan is the peace of mind that you hope that all of your wishes are properly executed, properly carried out, and then that your loved one will be taken care of properly. So what is a will? And we call it will for short, but then the legal term for that is, you probably you get into it, they call the last will and testament. Well, the last will and testament is a legal document that govern the distribution of your estate, your assets, your wealth, and it pretty much dictates who gets what after you died. Well, if somebody died without a will, that call the asset will go into what they call is the intestacy, which is the dying without a will. Then the estate go into intestacy, and then the state law will take control of your estate. And especially, like some of and I think that nowadays it's probably rarer to have this situation. But then if you have some let's say some investment account or some retirement account that don't have a correct beneficiary designation, then the court also make a decision by the state statute to give it to whoever they feel fit for it. Or even if you have minor children, and then like we said before, the court will appoint somebody to become the guardian of your minor children. So and then one other benefit of having a will versus, not having a will is the fact that you can control the impact of taxation on the transferring of your wealth to the next to your loved one. Now, so that basically what will is and what will can do, and the process of putting together a will can be, you can go to the extent, have it have a the legal expert, the professional to help you to put that together. But then, like back in the old days, somebody can sit down with a piece of paper and a pencil, and they write out all of the wishes that they want to have after they pass, and then that's what would be it. And like today, about 2/3 of the states in the Union, in the United States, would allow for what they call a holographic will, which is the handwritten type of will. Texas, our state definitely allow that holographic will with one condition, and that is it have to be handwritten from start to finish and with your signature on it. It wouldn't consider a valid holographic wills if you, let's say you started out writing a few things, and then you put it on the typewriter, word process it and print the rest out, in computer fonts and all that. That wouldn't be considered a valid holographic wills. It have to be all handwritten. And then the other, some state like Alabama, one state that kind of surprised me is like Minnesota. They don't allow holographic. Or even like Washington State, they don't allow it. That's about 12, 15 states that they don't accept. But with one leeway. Let's say if somebody witnessed you create a handwritten will in Texas with the state that allow holographic wills, and then you move to Alabama, and you die in Alabama, and your executor, the person that you assign to follow the instruction of the will, can prove that the will actually was handwritten in Texas, then now they will allow it, even though the state of Alabama don't allow holographic wills. So it's it's not that big a deal, but then nowadays I think it's always good to have it on the digital form, and then have witnesses and have signatures and all of that, legal acceptance with it, to make sure that it will work everywhere that you want it to work. And when you put together the will, then you make sure that you appoint somebody that we call the executor of your will, which means this is the person that you trusted enough to make sure that all of your wishes on the indicated on the will are properly executed. So will is a very, very big part of the estate planning process, and that was something that people think of first off when they thought about it. And then in the old days, there's also another form of will that we call, the legal term for that is non-cooperative, which is the oral will. Somebody said something, and then there's somebody witness it. That somebody have to be older than 14 years of age in order to be the acceptable witness for the oral will. But I don't know if, there's many of those things that, rolling around in the court nowadays, because, they, at least write it down on a piece of paper. Now, a part of the, when one the last thing I want to mention here is, make sure that when you set out to do this, make sure that you review the beneficiary designation of all of your retirement accounts and life insurance and investment account, things like that. Because in the court of law, in the probate court, the beneficiary designation on the retirement account and life insurance and investment account would override the instruction in the will. So a part of the will, it's just like the underlining part of putting the will, and make sure that the beneficiary designation on those accounts are up to date and the one that you want. Because I have seen people that they let's say they divorced somebody 20 years ago, but unintentionally the ex-spouse is still the beneficiary of their retirement account, which is something that they may not like to have. So those are the things that that you need to kind of keep an eye on the regular basis. The other part of estate plan that very commonly used, because it's a very important instrument that being used in the estate planning process, is a trust. And because of the trust and some of the subsequent issue that involve trust that happening when you as the person that put together the trust, in the legal term we call the grantor or the settler. You're doing it while you're still alive, so they call it the living trust. And there's some other reason they call it the living trust. But the trust is a legal arrangement, a legal document that put together to implement your estate planning goal. And the trust would appoint somebody called a trustee. It also is somebody that you trust in a family or friend. If you don't have a family member, friends, or somebody that you trust, to be the one that have the legal authority to execute all of those instructions in the trust. And once the trust is established, the grantor can now begin to move all of their valuable, all of their assets into the trust while you're still alive. So now you don't own those property, you don't own those assets anymore. The trust is the new owner of those assets. And all of those assets that the trust own from this point on, they call the corpus. And the corpus is the bulk, the main reason why the trust exists. And then the trustee is supposed to distribute the content of the corpus to a group or one person or a group of person called beneficiaries. Or the person, meaning a legal person, can be an organization or like a charity organization. And the big benefit of putting the trust together is this trust will will not have to go through what we call the probate process. As opposed to the will, they have to go, the executor of the trust have to file the will with the probate court. Now the trust, they don't have to do it. It bypassed this whole probate bar process, and as you can see, by bypassing the probate process, the survivors of the grantor of the trust can save a lot of time, a lot of court costs, a lot of the legal fees in general, in order to close out this chapter of their life. And another important part of having the trust bypassing the probate process is the fact that it can be everything that the content of the trust can be kept private, because for a lot of people, especially the wealthy people, the privacy matters. Let's say if somebody have like 2 or 3 children from the first marriage, and maybe a couple of more children from the second marriage, and then they have siblings, and they have nieces and nephews that they want to give a piece of their inheritance. Generally speaking, after that grantor passed, only the trustee and the beneficiary that related directly to that inheritance know what's being transferred, unless they don't share it with another person. That nobody need to know about it, because it doesn't have to be shared with everybody, as opposed to the will, because when the will go to probate, it become a public information, so to speak, and so the privacy is not the top high priority issue in the probate court, in the probate proceeding. So privacy matters, and trust is the one that can provide for that privacy for the family. Then the big part of this using trust for estate planning purposes is the fact that it can be very, very tax efficient, especially if you are the big business owner, you own multiple businesses, and you can plan for the business succession, who to take over this business A, business B, and how do that you did transfer. That can save the people, the loved one, your business partner, a lot of money in the future, using the trust implementation technique. Just due to the fact that, just think about it, there are 12 different types of trust that you can use for the estate planning purposes. And that 12 type that we're talking about here, not counting some of this hybrid type of trust that like for people that would use this type of trust and put that trust inside another trust, a different type of trust. So it's it's all very convoluted if you you follow that process. But then for the sake of this discussion, just keep that in mind. It's very private for the family and very tax efficient, because of of all the reason that we just mentioned. So, and then an estate plan would not be complete without addressing all of this, what we call collectively ancillary documents. So what are they? Well, the the first thing that we want to talk about here is a document we call the power of attorney, or a lot of time we hear people say the POA for short. We like to use acronym for everything. So POA is short for power of attorney. So what is it? Well, and I think that you guys probably already at one time or another have put together a POA or authorize a POA for some reason. I think that very, very common. For example, I normally recommend my clients that if they are planning for a long vacation out of town, now we travel the world, we can be out of the country for a month or two. That would be a good idea to have a power of attorney while you travel. It doesn't have to be anything to do with estate plan, even though the underlying thinking would be still that for the estate planning purposes. Why? Because if something happened while you travel during this extended period of time, somebody have the authorization to act on your behalf on some of these legal affairs or financial affairs, or maybe even like write a check for somebody, pay the bill, pay the rent or something. That would be when we travel, our daughter is our power of attorney. Or let's say if you buy a property in California and you cannot fly to California to sign the title paperwork for that property, maybe you want to appoint somebody, your POA in California, to do that for you. So that the power of attorney is a very important part of our life without realizing it. So that is when we alive and active and everything, but especially for estate planning purposes, you want to have a durable power of attorney just in case that you are not able to do it yourself. Because nowadays with a lot of people that have like dementia or Alzheimer, those are the definitely situations where they need to have a POA in place for that situation. And as far as the POA is concerned, so you can have a general POA, which means that this is somebody, like for us, we designate our daughter as our POA. That's a general designation. She can do anything that would need to be done for us. But then you can have, like the example I just present, like the situation in California. If you buy a property in California, you need somebody to sign the paperwork for you. That you can set up a limited POA, would mean specifically that POA for that purpose. Once that's done, that authorization expired. Now you can speaking of the POA, you can have, for the estate planning purposes, you need to have something called the medical power of attorney. Well, the medical power of attorney is important for the fact that, let's say if you incapacitated, then you need somebody to, number one, to be communicating with the medical professional. The doctor need to inform the family or discuss with somebody about your situation. The insurance company need to have somebody authorized to discuss this medical matter in your behalf. So on and on, anything that related to your medical condition need to have somebody authorized in your behalf to do it, and that is done through the medical POA. And another document that also are in this group of we call the ancillary documents are something called a living will. Well, this living will is really not a will, but it's just like, you know, something that you wish. That, you know, nowadays with the advancement of medical technology, the medical technology can help prolong human life almost like indefinitely. So this living will would be where somebody would express their wishes. They don't want to have any kind of life prolonging approach from the medical professional. When they, you know, when the end is there, then let it happen. You don't need any, you don't want any kind of life support, anything of that nature. Then that would be expressed and confirmed through the living will. Then you know, there's another document that's specifically called directive to the physician. That is exactly that, just for that purpose. And I don't know if you have parents or grandparents, you probably have seen a document called a DNR. And DNR, it actually is a form of directive to the physician. DNR is short for do not resuscitate. Somebody have this DNR form in their possession, or in the power of attorney's possession. So when the paramedics show up at the door and somebody have a stroke or heart attack, and you know that they can show this form to the medical professional, and they will not do anything artificial to revive you. So that is what it done through the directive to the physicians. All of that will, as part of all of that process that we normally sign, like when I get ready for my minor surgery, I have to sign a form called HIPAA authorization. The HIPAA authorization is a form that authorizes another person or another what they call the third party to discuss your medical, to look into your medical record, to discuss your medical condition, and receive your medical data, through the medical personnel. And this document is a lengthy legalese kind of the information with your one signature, and that is your signature to allow that to happen. Is that by law, nobody else can look into your medical record except you. Even the spouse have to be HIPAA authorized in order to do it. So pretty much this group of paper, like of the documents, like basically like about four basic forms that need to be included to make a complete estate planning plan. Now, so how do you start an estate planning conversation with the family? Well, this is a very, very delicate situation. This is a situation that is probably different from one family to the next, or one person to the next. But I'm just going to share with you some of the somewhat personal and somewhat professional opinion about some of these things. And let's start with how do you start a conversation with our parents, and then we will move on to how to start a conversation with the immediate family, the spouses, and the children's, and anybody else that you feel like that they need to be aware of the importance of estate plan. Well, for our parents, probably the first opportunity they have to go to a doctor for something that, mildly serious. Or the first, when people get old, they get to go to the emergency, clinics or hospital, or even just, any kind of medical help. Started out slowly, but then surely become more and more and more often. So our best shot at doing this without causing any kind of emotional firestorm is when we have to ask them to sign the first HIPAA authorization form. That would be the perfect opportunity to begin to mention and to have a conversation with our parents about estate plan, by using the need for ancillary documents, the power of attorney, the medical directive, the HIPAA authorizations, and along those lines, the four important basics estate plan documents that we want to include in their estate plan. So once we get into that conversation, then slowly but surely, our parents will begin to think about the end, and when they get that thought, the thought process going, then I think that would be better to start talking more about setting up, putting together the wheels and all of those things, because from, let's say, from my father-in-law, he passed away a year ago, not from COVID, but during the COVID time anyway. He expressed his wishes not to be to be what you call it, the cremate, but he wanted to be buried, because he'd seen his friend to be being cremated, and he didn't like that idea. So from that wish, we took the opportunity and they said, hey, what, if this is what you want, maybe this is a good opportunity. It's you need to put it down on some kind of written form, or and that is how we started for him to think about his will. And then we get other people, family member involved with the thing, and the next thing we know, he has a will. So I don't know if we have the time and get into some other example or some other situation, but you get my idea of using some of this opportunity, and most of the time the medical opportunity, or some of the conversation, or somebody that we know, the family knows, passed away, and do you know that Mr. Smith passed away without a will? That's kind of leading question will help ease us into having a more and more serious discussion, a conversation with our parents, and the same thing with our family. And when we do the estate planning for our parents, that process, we can begin to have some what I call the storytelling approach with our children, and of course the spouse that need to be involved with that process. So all of that should happen, not necessarily have to be concurrently. It probably should be shared. We should keep them posted, so that when we get done with one, we can ease right into the one without really have to kind of restart the thought process and the conversation and everything, because the thinking's already there, the understanding already there. It's just a matter of making it happen. So I think that telling the story, other people's story, or your personal experience story, is always a good approach to have the heart-to-heart conversation with the spouse, have the good understanding of the process with your children. And another easy one to do, let's say if you set up an life insurance policy for you and your spouse, and of course we all do, generally speaking, we put our children as the beneficiary. Well, that would be a perfect opportunity to tell them about the estate planning, starting now with the beneficiary designation and the importance of having a will. So those are the things that we come across, we run into pretty much like every day. But because we don't think about estate planning, we don't take advantage of opportunity to begin that very constructive conversation with our family. So I think that would be the good place to start the conversation. And I like the approach of storytelling approach, because that's always get people attention quicker and longer. Now, so all the information that we gather, and with the wish to have one, to make it happen, wouldn't do any good if we don't take this first step to make it happen. So where do we start? How do you get started? Well, I think that attending this seminar, or many other, there's a lot of conversation about estate planning. You can find anywhere, happening every day around us. So that would be the first important step, to self-educate about the subject. And once we have a feel for it, I think that it's important for each person or each family to begin to gather some of the information, gather some of the document, to see where we are. Just like we use the word, taking an inventory of where we are, what we have for the estate planning process, and take advantage of those, what they call, we call nowadays a complementary consultation session. And there are law firm, attorney, group attorney offices out there, or in investment company, retirement company out there that offer this type of services for the community. So those are the opportunity for us to really get our hand, into the estate planning process for ourselves. And we would not, in my culture, we have the saying called a 10,000-mile journey. Take the first step. And if you don't take that first step, the 10,000-mile journey will never happen. You never finish it. So I would, end this presentation by really encourage everybody to take that first step, and you will see the joy of having it done is far outweigh the confusion and the hesitation and the confusion and sometimes the pain of the journey. So again, we supposed to have some kind of legal disclaimer about this. This information provided in this presentation is purely intended for education purpose only. We don't intend to provide any kind of advice, legal advice or financial advice or for anybody. So in order for us individually to have a more in-depth discussion or want to learn more about the process, or you have a specific question, issues, concern about any kind of situations, then either your situation or somebody else, we encourage you to consult with a legal professional to get those question, issues, concerns addressed accordingly. So before I end, once again I like to thanks Ms. Jennifer and her staff for putting this meeting together. And I once again I want to thank you for participating in this process and this meeting, and thanks for your attention to my presentation.
And we have
some time for
questions,
Q&A. So let's see if how far we can go with your Q&As, and if anything that I cannot properly address for you today, I certainly would be happy to address it offline, so to speak. Okay, thank you.
All right, so we do have a couple questions already in the chat, okay. So I'll ask those, and if you have additional questions, just drop them in there. So the first question is, would a medical power of attorney be a good document to have for a child that is now 18 years old?
Say it again. I'm sorry. I thought I'm reading the question online here. So yeah.
Yeah. So if you have a child who's already 18, would it be a good idea for them to have a medical power of attorney in case something happens to them?
I think that generally speaking, if that, and I think state of Texas, 18 is the, consider a legal age. So I think that if they want, okay, because now if when your child is 18, the parent really don't have any kind of don't have the legal authorization to decide to make them sign any kind of paper or anything like that. So if they want to have one, then I think that would be we have to honor their wish. So that would be my general answer for that question. But then well, let's say if I have client who has special need children, even though they are legally adult, but because of the capacity they in, they have a legal guardian, and that guardian would be fully legally to have a medical directive for that special need child. I shouldn't say child, but that special need person.
All right, next question. So this is about a living trust. So once you complete the living trust, did I understand that the items listed are no longer owned by the person, but are instead owned by the new trustee?
Okay, I think that, let me make it clear. I think that's a very good question. The trustee doesn't own the asset in the trust. The trustee is authorized to execute, to distribute when the time to do it. The trust is the owner of the person, not the trustee.
So the trust owns
The trust
like
is
property.
in the legal definition, a trust is a legal entity. So instead of the grantor own the asset, now the trust is the legal entity that own the assets, but not the trustee.
And the trustee just has to follow whatever instructions are in the trust.
Yes.
All right. Do we have any other questions? Okay, one. Do you normally pay a trustee a fee?
Well, that would be a that would be an arrangement between the grantor and the trustee. Well, and keep in mind, a grantor can double up being the trustee for their own trust also. So if they decide to pay themselves a salary to be, to be the trustee, that that their own choice. But then that is more, I think the easiest answer for that question is the trustee may or may not get a stipend for the work that they do, because sometimes if the work if you own a whole bunch of businesses and a lot of property, scattered all over the places, and you got a long list of beneficiary that you need to we need to tend to. Now the work become very, very time consuming and very, very very involved. Maybe you want to compensate somebody for all of the time and the effort and the headache that they have to put into to do it for you, but it's all depend on the how the two sides of work agree together.
All right, that makes sense. All right, this is going to be our last question. So we have a question asking, how would we contact you for additional support? I have your email address. Are you okay if I put that in the chat?
That was I was going to say. I think that for the purpose of this this meeting, I would like for everybody to contact me through Ms. Jennifer. She has all of my contact information, and I can tell you I don't mind to address any kind of question or issue that you have, because that is something that I do most of my days. So yeah, but feel free to do it, and please do it through the Forward Public Library with Mrs. That's pronounce your last name correctly, Demas?
It's Demas.
Demas. Okay, please.
So all of you, when you received your Zoom link, my email is in that. So if you have any questions, you can send them to me, and then I'll forward them on to Dawn. And that is getting us right at time. So I want to thank everybody for coming today. And I want to thank Dawn for his time. We hope you got some good information. Tomorrow, you'll get an email from Zoom with a link to a quick survey. The information that you provide on the survey helps us plan for future presentations. And we have several financial planning presentations this year, and they'll all be presented as in the Lunch and Learn format. So visit our website, fortworthlibrary.org, for more information. And we did record today's presentation, and we'll post it to our YouTube page in the next week or so you can rewatch it and look at it again. And we'd love for you to subscribe to our channel and turn on those notifications to get stuff when we post it. So thank you very much. And I hope everyone has a great day.
Thank you.